All right, we have a few more participants that are still just getting added in, but I'll go ahead and get started with the introductions. My name is Shauna Correia. I am a partner in the San Francisco office. I'm in the Labor and Employment Law Group, and I am presenting today with my partner, Lukas Clary, who's a partner in the San Francisco office in our Labor and Employment Group, and our Associate Extraordinaire, Katie Collins, who supports us and is doing a lot of work, particularly with wage and hour. So she is our wage and hour guru, and I'm pleased to be presenting with both of them today. We actually have more time than usual, so we don't have to blast through all the slides like we've had to do in the past. We've broken up this webinar from prior year formats to 2 separate sections. So this is just covering the wage and hour section. And then the second section will be, I believe, the 17th. And that will cover other topics like leaves and accommodations. So this is just going to be the class action, PAGA, wage and hour related issues today. And here's all of our contact information. This will be in the packet that Ramona has emailed out to all of you as a blast with the copy of the presentation. And we will go ahead and get started with Lukas taking it away, starting with independent contractors. Go ahead, Lukas.
Thank you, Shauna, and good morning, everybody. Yeah, so as Shauna mentioned, we're covering today. In the past, we used to do this one big 3-hour plus presentation where we did all of the annual employment updates, and now we've broken it up into 2 sections. So today will be that wage and hour component. When we're talking about wage and hour laws, it always starts with what I call classification issues. There are 2 types of workers who may be subject to less wage and hour compliance than most of your workforce. And those are the workers who are exempt from many of the wage and hour compliance laws. And Katie will talk a little bit about some updates in that area in a little while. And then also workers who are not in fact employees at all, who are independent contractors and are not really subject to most of the wage and hour laws that govern employees. So it can be tempting to classify workers as independent contractors so that you don't have to deal with all of that compliance. However, as many of you probably know, it's not as simple as just deciding whether to call someone an independent contractor rather than an employee. There's a whole host of laws that govern that. And there have been a few updates to that area of the law this year that I want to talk to you about briefly. So I'm just going to jump into the next slide.
Hey, Lukas, before you do that, I neglected to mention, and I wanted to just interrupt before you get into the meat of what you're going to talk about. People may have questions. If you have questions for any of us as you go through, please use the Q&A feature. Don't use the raise hand or the chat. We've disabled those features. That just allows us to field all your questions and monitor them. And we may take some of the questions as we go through, but we'll leave plenty of time for Q&A at the end, and we'll make sure we try to cover those questions at the end. Sorry, Lukas.
Yeah, no, I'm glad you clarified that. And yeah, if you ask, if I'm talking about something and you put a question in the Q&A, if I notice it as I'm speaking and can kind of answer it on the fly, I'll be happy to do so. Otherwise, I'll come back at the end, as Shauna mentioned. So as far as legal updates every year, they come in one of 2 ways by and large. They either come through case law, meaning the courts, a lawsuit works its way through the court system, becomes a published appellate opinion, and that becomes law binding on everyone else, or through legislative action. The legislator, makes laws that impact certain employers. So in the independent contractor space this year, we've had some activity from both of those places. From the legislature, we've had AB 1561, which is what I would classify as more of a cleanup, clarification type of bill that helps, deal with some of the evolving independent contractor law we've had over the last couple of years. It's been quite a whirlwind. You go back as far as 2018, we had this landmark California Supreme Court case, the Dynamics opinion, which took what had been decades of understood analysis around whether someone's an employee or an independent contractor, and kind of turned it on its head. It introduced this new test, this ABC test that many of you may be familiar with. And I actually have in a couple slides, I will kind of recap that, even though that's not a new thing, just as a refresher in light of these new laws that I am talking about. So that was the Dynamics opinion. A year later, we had AB 5, which was a bill from the legislature that made clear that this ABC test that Dynamics established was going to apply across the board unless you had an exception for all aspects of California labor law analysis. And that law, AB 5, came out, it very heavily fought. A lot of industry poured millions of dollars into opposing it. A lot of industries got themselves some exceptions, carve outs from the ABC test before it passed, some not as successful, but what it left was kind of a mess in its wake. And there were a lot of questions about these various exemptions that applied. And so we had last year a cleanup bill, AB 2257, which expanded the lists of entities that were exempt from the ABC test for independent contractor analysis. That law was set to expire at the end of, and actually it says this year on the slide, I'm at the end of last year. So as of now, January would have already been expired. But we got AB 1561, which expanded those exemptions through the end of 2024 and provided some clarifications on some of them. So if you're in one of these industries, you see these bullet point slides here: licensed manicurists, certain construction truck workers, in the insurance industry, claims adjusters and third-party administrators, various manufactured housing salespeople. You think about the people the real estate people who sell manufactured homes. All of these people have exemptions according to AB 1561 through 2024 from this ABC test that we've all been learning about over the last few years. Now, what I want to clarify here, though, is if someone is exempt from the ABC test, if you're in one of these industries, that does not mean you can automatically classify them as a independent contractor rather than an employee. What it means is people who have these exemptions, these people in these industries, and there are others from AB 2257 and AB 5, there are other industries who have exemptions as well, but that's established law. I'm bringing this up because these are new ones that come out from the new bill. So if you're in one of these industries, we look at the prior test, which we call the Borrello test. It's named after the case that established it for determining independent contractor status. And there are a whole host of factors. I won't get into all of them here. It exceeds the scope of what we're talking about today, but 13 different factors that largely revolve around how much control is exercised over the worker by the business. But the important takeaway is you still have to satisfy that test to call someone an independent contractor, even in these industries you're looking at on this slide. So if you're in one of those industries or an industry that has another carve out under prior law from the ABC test, you still want to go through that analysis of the Borrello test. And if you need to work with your counsel on that, you should do so to make sure you're properly classifying someone as an independent contractor. So that's what the legislature gave us this year on independent contractors. We had one court opinion on this issue as well, and it's pretty industry specific. It deals with the trucking industry and specifically interstate truck drivers. So this is truck drivers who either drive their trucks across state lines or at minimum are hauling goods that in the course of commerce those goods themselves cross state lines. If you don't meet one of those things, if you're what I would call an intrastate trucker, meaning only within California, driving only within California, carrying goods only within California, there's no exception for you. You're part of the ABC test like most workers out there. But for these interstate drivers, there's been this fight working its way through the courts on whether those type of drivers were exempt from AB 5. Okay, so the argument being by the trucking industry that they're exempt from AB 5 because there's this body of federal law, that F4As, which is a mouthful, I won't say the whole thing, but FAAA is a body of federal law that says we, the federal government, provide laws relating to interstate trucking, the price, the routes, the service of any motor carrier that's transporting property. And this body of law expressly preempts, meaning precludes states or local governments from enacting laws that relate to these things. The federal government has said we are the only ones that can weigh in on these issues, the price, route, service of motor carrier. And so the trucking industry has argued because of that law, AB 5 is preempted. These categories of truck drivers don't have to apply by it to be considered an independent contractor. And this is a huge issue in this industry because most, as any of you who have workers in this workforce as part of your operations, most of this industry has historically relied on an independent contractor model. Most of the truck drivers out there, certainly there are a whole lot that are employees of the companies they drive for, but many, if not most of them, own and operate their own truck as independent contractors that just contract with businesses to haul goods. And AB 5 has kind of turned that on its head and said you have to call those people employees most likely. So this has been a big issue, and they actually had a favorable ruling in the initial trial court level. The district court level said, yes, the F4A does preempt AB 5 and you don't have to comply with it. But as these things do, that was appealed to the Ninth Circuit. And the Ninth Circuit in 2021 issued an opinion that says we disagree. The F4A and federal law does not preempt AB 5. The reason, the logic that the Ninth Circuit had behind that is that AB 5 is just a generally applicable labor law. It's just about labor. It doesn't impact the price, route, or service of a motor carrier. And because of that, it doesn't preempt AB 5. And so that's the current status of the law. Now, this fight is not over. It's still working its way through the court process. The Ninth Circuit issued this opinion via what we call, and this is getting into the legal weeds, but what we call an en-banc panel, meaning just a small sample of the judges on the Ninth Circuit. So we may still get a different ruling from the entire body of Ninth Circuit judges. And whether that happens or not, we may get an appeal to the United States Supreme Court. So it could still work its way through the process for a couple more years before we ultimately know where this is going to go. But the status quo as of right now, in light of this opinion, is that even interstate truck drivers who pass through California are subject to AB 5 and most likely should be classified as employees, because without getting too deep into it, it's almost impossible for a truck driver hauling goods for a trucking company to satisfy the ABC test and be considered a contractor. There will almost always be an employee under that test. So something to continue to watch and comply with if you're in that industry. And just really briefly before I leave this issue, a recap on what that ABC test is, because it's going to govern most of your workforce. And this is not a new 2021, 2022 law, but in light of these issues I'm discussing, I just want to recap it. That ABC is a three-pronged test that looks at those three factors you're seeing on the screen there. Factor A, does the business control the work and the manner and means in which the work is done? If so, you're not going to satisfy prong A. Even if you do satisfy prong A, is the work outside the company's usual course of business? So sticking with that truck driving example, if you're a trucking and transportation company and you hire a driver to drive a truck, that's directly within the course of what your business is, the core of what your business is. And that's why they would never satisfy prong B. Lawyers are not a great example because we are actually one of those exemptions that has come out over the years. But just to provide another illustration, our firm, as a law firm, we're engaged in the business of providing legal services. If we hired a lawyer to perform legal services for our clients, that's directly within the course of business that we perform. So they wouldn't satisfy prong B of this test, right? And then prong C, the third one, are they customarily engaged in independent trade or business? Essentially, are they out holding themselves out there as doing the business that you're hiring them to do? Do they have other clients? Are they trying to get other clients? Or are they only performing the work for your company? If they're only performing the work for your company and not trying to get other work, they're not going to satisfy prong C. And then lastly, why does this all matter? Because if you're classifying someone as a contractor and they in fact should have been classified as an employee, you're probably not monitoring hours. You're probably not making sure that they're making at least minimum wage for every hour that they work, that they're being paid overtime and getting meal and rest breaks if they work the number of hours that trigger that. You're probably not reimbursing their business expenses the way you would with an employee. And these are all areas in which you'd have liability if you're misclassifying people as contractors and you get dinged for that. So that's the independent contractor issues. Now I'll jump into just general wage and hour law that impacts most of your workforce, your non-exempt employees, people who you can't classify as contractors and you can't classify as exempt from various labor laws. So there have been a whole host of both legislative and court laws that impact this segment of the workforce as well. And I will jump into that, starting with the legislative action. So AB 1003 is a new law that was passed that is now in effect, took effect a few days ago on January 1, that can actually make what's considered wage theft a crime, punishable as felony grand theft. Now, it might seem like common sense to think, well, yeah, you steal somebody's wages, you're stealing, that's a crime. However, this is a little bit more intense than that in my view, and it might impact you in ways that go beyond that. First of all, let's start about what the statute talks about when it says wage theft. It talks about failing to pay someone their wages, what they're entitled to for working for you, when you have knowledge that they are in fact owed it, that the compensation is due. Now that may seem like it's only intentional theft, and in fact the statute says we're only dealing with intentional, we're not dealing with negligence or accidental failure to pay wages. However, I have some concerns there, because if you look at the way the courts and government agencies interpret these types of laws traditionally, they will interpret that language broadly. I'll give you another example. The labor code, many of you may be familiar with what we call waiting time penalties that are owed to employees who are not paid everything they're owed by their final day of employment. You terminate someone or they quit, they're supposed to get their last check on their last day, not wait till the regular pay period, something like that. So there's a body of law that imposes penalties on employers for failing to comply with that. And it has similar intentional language in there. It actually uses the word willful, but it says it's got to be willful. We're not dealing with accidental failure to pay. But when these claims work their way through courts or through the labor commissioner, it's almost always the case that if you get dinged for failing to pay wages, you get hit for the penalties, the waiting time penalties, because it's deemed willful. And I could see a similar thing happening here with oversights and miscalculations. You might run afoul of this law, and you might find yourselves not only facing penalties, but also potential criminal prosecution. So this law doesn't impose new obligations on an employer necessarily. I mean, there's already your obligation to pay people their wages if they've earned them. But what it does is it underscores the heavy-handedness at which the legislator is taking steps to enforce these laws. And it really underscores the importance of making sure you are paying everyone what they are in fact owed. One last thing on this one that's relatively industry specific, but if your workforce, if your employees make tips, those tips themselves are subject to this area of the law. So, hospitality industry, any type of service, salons, anything where the workers are tipped. If they're tipped, say by credit card, and that works its way through your system, and you have to turn that money over, that tip money is subject to this body of law, and that's different from a lot of areas. Traditionally, gratuities are not considered wages, but for the purposes of this law, they are classified as wages. Moving to the next one. This is another one that's relatively industry specific, dealing with warehouse distribution employees. So if you have employees whose job is to work at a warehouse and distribute goods, and there are quotas attached to the type of work they do, and that this is fairly common in this industry. You have to process a certain amount of boxes per hour or per day, or get a certain amount of boxes off of the conveyor belt per day, or something like that. Any type of quota that these workers are subject to, and where the failure to meet that quota can result in disciplinary action. If you are subject to this new body of law, AB 701, you may have an obligation up front to inform those employees of what those quotas are and what the consequences are of not complying with them. Otherwise, you won't be able to enforce them. And who's subject to this? It's if you are considered a large employer, meaning you have at least 100 employees at one single warehouse, or cumulatively throughout the state, you have at least 1,000 warehouse employees. If you meet that definition, you're subject to this body of law, and you cannot take adverse employment action against an employee who fails to meet a quota unless you've in fact let them know in writing up front what their obligations are and what those consequences are. And this is pretty crazy, right? Because this is in fact doing away in some ways with at-will employment, in that one of the things employers have always had is the ability to say, if an employee is not meeting my expectations, I can let them go at any time if they're an at-will employee. Well, in this context, if they're not meeting your expectations, you cannot use that as a basis to separate employment or to take any adverse employment action, suspension, dock and pay, demotion, anything like that, unless you've complied up front with letting them know in writing what this is. It also, in addition to preventing employees from having to, or preventing employers from being able to enforce the quotas without letting employees know up front, it prohibits quotas that are deemed so onerous that they prevent employees from taking meal or rest breaks, or complying with health and safety laws under OSHA. Meaning if the effort to meet the quota means that employees have to miss meal breaks or rest breaks because they're too busy, then that quota is going to be prohibited. And that's the area of the law, of this new law, AB 701, that I think we're going to see litigation around. I think most employers, if they're relatively sophisticated in this space, are going to go ahead and come up with that written quota up front and comply with that. But the employees, when they go talk to plaintiffs' attorneys, are going to argue, I couldn't take my meal breaks and rest breaks if I met this quota in order to meet this quota. And I think we're going to see litigation around that issue. So if you're in this space, if you're working here, make sure you are aware of this, and if need be, talk to your legal counsel about whether your quota policy is compliant. Okay, moving on. Oh. Didn't mean to jump so far ahead. Another one that's fairly industry specific, in the garment manufacturing industry, people who make clothes, essentially, you cannot pay these workers on a piece rate basis. So piece rate pay, for anyone who's unfamiliar, is something alternative to paying them for their time. Instead of paying them by the hour, $15, $20, $25 an hour, or whatever it may be, they're paid X amount of dollars for getting Y task done. So sticking with this industry before this law, if you complete 100 dresses, you get paid X amount of money, you know, or this much per dress stitched, or, you know, whatever it may be. That is now forbidden in this industry unless they're unionized employees and it's been collectively bargained that they'll be paid on a piece rate basis. So if you're in this space, and it's not just the garment manufacturers, but also the brand guarantor. So even if your company isn't the one making the clothes, but you're in fact placing your label on it and selling them, you're subject to this. And if you're doing it wrong, you're most likely going to see a lawsuit brought on behalf of the entire workforce. $200 per employee per pay period, going back at least a year, multiplied by your entire workforce. You can see how liability, the numbers can get pretty high pretty fast. So that's an important one if you're in this industry. And I always say, if you're not in the industry that the law applies to, it can be easy to gloss over and say, this doesn't apply to my business, so why do I care about this? Yes, there's some truth to that, but it's always something to be mindful of and watch, because a lot of times you'll see these types of laws come out and they start industry specific, and eventually they're expanded to include other industries and then just the general workforce as well. So what we know about this one is there's efforts by the labor unions in this space to prevent piece rate pay. You know, that's why there's an exception if it's collectively bargained, because they want to encourage unionizing workforce, the people who are pushing these laws. And you may see them do the same thing in other spaces as well. So piece rate pay could be under attack if that continues. Another industry specific one, the janitorial exemption is, it's actually, I believe it's only the second time ever that we've gotten a carve out from businesses that are subject to PAGA lawsuits. So if anyone's unfamiliar with PAGA, one of the four-letter words of labor and employment law, these are lawsuits that are very similar to class action lawsuits, but where it allows members of the workforce to essentially step into the shoes of the state, acting as a, quote, private attorney general and enforcing labor code violations, not just that they have experienced, but that anyone in that workforce has experienced, and they can create nightmare lawsuits for businesses. Some of you may have gone through them and learned the hard way how difficult they are to deal with. So there have been, the PAGA body of law has been in place for a couple decades now, and there have been almost the entire time efforts by various industry organizations, human resources associations, you name it, to get reform to this PAGA body of law, and it's been largely unsuccessful. Well, here's one of the few industries that actually did, and it's certain janitorial employees cannot be subject to PAGA lawsuits provided certain things are met. If they are union represented, and in fact had already been union represented before January 1 of last year, then this may apply to them. That collective bargaining agreement that they have has to be in effect before July 1 of 2028. So there is a sunset, a shelf life on this law, at least as of right now. And it must include those other bullet points. The CBA has to have terms that govern how they're paid, their wages and their hours. It has to provide that they get overtime. It doesn't necessarily have to be identical to California overtime law. It's got to be at least at minimum compliant with that, but it could provide for others. There's got to be an overtime component to the CBA. Has to have that grievance and a binding arbitration process. Or, excuse me, that's not what the CBA must have. That's what happens if you have those elements in your CBA and you're exempt from this law. What happens is then employees who have what would be PAGA claims instead file a grievance. They go through binding arbitration and they can be paid, but it's a lot less of a headache for the business. Now, for whatever reason, as these laws get passed through this legislator, we always see exceptions to them, and we have some here that wipes out, I think, a lot of janitorial workers. The grocery store, hospitality industry, housekeeping staff, they're not subject to this. So those people can still file PAGA lawsuits, notwithstanding this body of law. One other legislative update for those who work in the general contractor, subcontractor space, where you have that kind of relationship. It's already been the place even prior to SB 727 that was passed last year and is now in effect. It was already the case that general contractors could have exposure to and be held jointly liable when subs fail to pay their workers wages owed or fail to provide benefits that those workers are entitled to. What has expanded through SB 727 is those general contractors now can face penalties and liquidated damages, as well as the obligation to pay the wages. So it's given more teeth to this issue of making sure that general contractors take steps to affirmatively assure that their subcontractors they work with are treating their employees properly under California labor and employment law. So if you in fact work with subcontractors, make sure that's part of the process of what you do, to have something in your contracts with them that gives you the right to monitor and ensure compliance with wage and hour laws. Maybe you have language that you're not obligated to pay them until they can show you that they've paid their employees properly. You might also want language in there that indemnifies the general contractor if they get hit because of the subcontractor's failures, which is only worthwhile if the subcontractor has the ability to indemnify and make the general contractor whole. Really, if you're in this space, I would work with your legal counsel to make sure you're properly set up to deal with subcontractors and make sure they comply with wage and hour laws. Some penalties. This, again, another one that doesn't necessarily impose new obligations on employers, but it's just the enforcement action, underscoring how important it is to comply with these laws. The labor commissioner now under SB 572 can actually take steps to lien real estate in order to enforce their citations, their findings, their decisions. If you get dinged for something by a labor commissioner, then they can do that as a method of enforcing it. They can put a lien on your real estate. And that's not just the case for companies, for businesses, because there are aspects of the labor code that create personal liability for those directly responsible for violations. So if you're a managing agent of the company and you're the one who is personally responsible for a failure to pay wages because of decisions you're making, there's at least theoretically a path to you being held personally liable for whatever the penalty is. And if you don't pay it, your home could get slapped with a lien by the labor commissioner. So again, there's nothing new you have to do as a result of this body of law, but it just underscores how important it is to make sure you're complying with labor law. Okay, so enough from the legislator, and I'll talk a little bit about what the courts have done in the space of non-exempt employees and wage and hour laws. So we had this case, L&E v. Dragas, that deals with dual rates of pay. So this is the scenario where you might pay employees two different rates depending on what they're doing. You see this maybe come up if driving is part of the job, maybe they make a certain rate while they're driving to and from jobs and a different rate while they're doing the jobs. Scenarios like that. In this particular case, Buffalo Wild Wings had employees who they maybe made a base minimum wage when they were serving and making tips, but then sometimes they also worked a managing job where they couldn't make tips, but they got a higher rate of pay, or they were working in the kitchen and the tips were less and they got a higher rate of pay there. For whatever reason, these employees would sometimes make, let's call it $15 an hour, and sometimes make, let's call it $20 an hour. So what Buffalo Wild Wings did in that situation was, if the employee worked overtime, they would pay them overtime, the time and a half or double time as it may be, based on the hourly rate that was in effect at the time they went into overtime. So if they were making that higher of the two rates, they would get overtime on that. If they were making the lower of the two rates, they would get overtime on that. So a class of Buffalo Wild Wings employees sued and said, that's the wrong way to do it. You need to be paying us the weighted average of the two ways, which the DLSE, the labor commissioner, they have an enforcement manual, which a lot of us lawyers rely on and a lot of HR professionals probably use as well, that basically clarifies a lot of labor laws out there and how they think they think employers need to do to comply. Now that enforcement manual says that weighted average is the correct way. The way that these employees are arguing they should have been paid, that's the correct way to do it. Now, the court, as this worked its way through the court system, we actually had a positive result for employers. The rare time, we give you these updates every year and we tell you what the courts have done and what the legislators have done. And it's basically, in short, how they've made it harder and how they've made it worse. This one had been, and I say had, and there's a caveat here, one of the exceptions where it actually went the other way. This court said, look, that DLSE enforcement manual, it's persuasive. We'll look at it. It's important to know how the DLSE views this, but it's not binding on us. It's not a statute. It's not a regulation. It's not law that we have to follow as a court. And we're interpreting the labor code differently. We think the way Buffalo Wild Wings did it by paying the rate in effect at that time is allowed. We think that's okay. So hooray, great development for employers, right? Short-lived though, because for whatever reason, after issuing this opinion, the California Appellate Court decided, they were likely asked by somebody to do this and agreed to depublish the opinion. And what that means as lawyers who interpret law and apply law know, you cannot cite to unpublished California opinions as binding authority. It's only published opinions that are binding. So now we're back to this confusion. Is the DLSE manual the only way to do it? Or is it okay, as this court thought, to in fact pay the rate in effect over time? The takeaway, I think, right now is that it's probably still safer to use the weighted average. Certainly if you're getting challenged on this in front of the labor commissioner because someone's brought a claim there, they're going to look at that DLSE manual. They're going to say, this is our manual. We agree with it. This is how it needs to be done. If you're in court, there's a chance it'll go the way this court decided. There's a chance a different judge or series of judges would say, we agree with the DLSE. Probably safer to stick with the weighted average, but it's something to monitor. So just another recap slide real quick on what that means exactly, the weighted average. Taking the example on this slide, let's say you have an employee who works 30 hours one week at $15 an hour and 22 hours the same week at $25 an hour. So because that employee worked more than 40 hours in the week, we know they're entitled to overtime. They get 12 hours of overtime that week. We'll put aside for the purposes of this hypothetical daily overtime on more than 8 hours in a day and all that. We'll just look at weekly. This person, because if you look at the two rates they earn, 15 times 30 is 450, 25 an hour times those 22 hours is 550. They earned $1,000 that pay period. $1,000 divided by the 50 hours they worked, it's $20 an hour. That's the rate of pay you would need to pay overtime. So that's how you do a weighted average, as opposed to just paying, the overtime on whatever hourly rate they were making when it went into when the overtime kicked in. So with that, is this one yours, Katie, or am I taking this one?
I'm happy to jump in. I was going to jump in on the next one, but
I can keep this one.
Okay.
I wasn't sure where we were trading off. Okay, so last one I will give you, and then I'll turn over to Katie to do a couple more and talk about non-exempt employees. But this case, General Atomics v. Superior Court, this dealt with wage statement compliance. So under Labor Code Section 226, there are 9 different things that need to be on a wage statement, that statement that accompanies paychecks, to be compliant. And as some of you may know, and some of you may have learned through one of those PAGA lawsuits, the penalties for non-compliance with this body of law, even technical non-compliance, something like not having the company address on the wage statement, can result in substantial, 6 figures in some cases, sometimes more, liability to companies. So it's an important body of law to comply with. This is another case in which employers caught a break. This employer, General Atomics, this is how their wage statement listed overtime, and hourly rate that you make and the overtime hours, all of that are part of those 9 things that have to be on the wage statement. So what this company did is they listed all hours in one column. You worked 90 hours this pay period, and you were paid $20 an hour for all 90 of these hours. Then it has a second column that says 10 of those hours are overtime. For these 10 hours, you also get 0.5 times your regular rate of pay for those 10 hours. So what as we hopefully all know, both California and federal law requires overtime to be paid at 1.5 times. 2 times obviously if we're over 12 hours in a day, but just to keep it simple right now, let's stick with the 1.5 times. 1.5 times the regular rate of pay. So these employees sued saying your wage statements aren't compliant. They're not telling us that we're making 1.5 times our regular rate of pay for all overtime hours. They're just telling us we're making 0.5 times the regular rate of pay for the overtime hours, and they're keeping the other hours on our straight time regular rate of pay. It's probably a little confusing. Hopefully you're still with me, but let me know if you have questions. So the employees argued that these are not compliant wage statements. The court disagreed. The court said these are compliant wage statements because employees can look at them and they can determine based on the wage statement whether everything was correctly calculated. It shows all of the hours total. It shows the amount you got paid total. You can look at it, you can do the math, you can figure it out, and that's all the statute requires. So another good one from the court here. So if you're doing it this way, you're okay. I think the more important takeaway is while there are multiple ways to do this, make sure you are adequately conveying to the employees exactly what they're being paid, exactly how many hours they're being worked, the rate for overtime, all of that, so that they can look at their statement and figure it out. With that, I will turn it over to Katie.
Good morning. As Shauna said, my name is Katie Collins. I'm an associate in the Labor and Employment Group, and I'm just going to talk to you a little bit further about non-exempt employees, and then we're going to touch on exempt employees. I know we're throwing a lot of different numbers and calculations at you, so I hope you're still with us at this point. So first, I'm going to talk about a case about the trucking industry. So if you employ individuals that drive trucks, pay special attention to this. There's a case called International Brotherhood of Teamsters versus FMCSA. And for those that don't know, FMCSA stands for the Federal Motor Carrier Safety Administration. This case addressed whether the FMCSA can preempt California laws governing meal and rest breaks, which preempt basically means that we would listen to the FMCSA and disregard the California laws that we are typically dealing with as the 5th hour for taking the meal period and our standard laws regarding those. The Department of Transportation through FMCSA imposes restriction on interstate drivers' hours of service. Drivers working more than 8 hours must take a 30-minute break within the first 8 hours. There's an important distinction here between the words interstate and intrastate, which I'm sure you are all familiar with. Interstate are those individuals that are traveling across state lines, whereas intrastate is drivers that are just driving within California. So here we're talking about interstate drivers. So drivers that are crossing the state line are subject to the FMCSA. Here, the FMCSA reversed their prior determination, finding, my apologies, finding that the federal law preempted California meal and rest law. Teamsters challenged the determination, but the 9th Circuit ultimately agreed with the FMCSA. So here, they ultimately decided that FMCSA does preempt California laws when it comes to interstate motor carriers. So interstate motor carriers are not required to comply with California meal and rest requirements. However, if you have drivers that are driving only within California and are intrastate drivers, the California meal and rest break laws still apply. And there's a group of cases came out, certified tire and service centers wage and hour cases. Here we were talking about individuals that were receiving additional funds for productivity. So they were guaranteed a base hourly rate of $14 an hour, but they could earn a higher hourly rate by hitting certain productivity measures. This was based on the number of dollars that were billed to the customers that the employer had for the employee's labor in particular. Some employees would earn up to $70 per hour under this formula, obviously dependent on their productivity and the clients they were working with. So Labor Code Section 226.2 requires that employees paid on a piece rate or commission basis must be separately compensated for rest periods and non-productive time. Here, the plaintiffs argued that the employer's compensation policy, which provided that base hourly rate, but then allowed for productivity bonuses essentially on top of that, was in violation of Labor Code Section 226.2. The court held that the policy did not violate the law because employees made the hourly rate for all hours worked. So that $14 an hour base rate was made for all hours worked, including rest periods, including non-productive time. So what the employer decided to pay on top of that based on productivity was not going to make them violate the law itself because they were already doing the $14 for every hour worked. It's important to keep in mind if you have piece rate or commissioned employees, that area of law and that type of payment can be very challenging. So make sure you work with legal counsel in crafting the policies. And now to move on to exempt employees. We just posted a blog yesterday, which hopefully you guys all got a blast on, about minimum wage updates. So as we all know, we're now in 2022, which seems crazy, but here we are. With 2022 comes new minimum wage for the state, also minimum exempt salaries, as are touched on in this slide. But we also have minimum wages in many different cities across the state of California. So to the extent you have employees across the state touching in different cities, it's important that you check the minimum wage and make sure that you're in compliance with the city minimum wage, the county minimum wage, and then also California minimum wage. The blog should be a useful tool for you there. It includes a chart which will touch on any and all minimum wages that your employees might be imposed on. So here, 25 or less employees are required to be paid $1,120 per week, $58,240 per year. This is in particular for minimum exempt employees. So these are the minimum salaries that an exempt employee must be paid as of January 1st of this year. For employers that have 26 plus employees, they're required to be paid $62,400 per year. And then there are also some requirements for those that work in the computer software industry and licensed physicians and surgeons. So just make sure that you are checking every resource possible to ensure that your employees are being paid correctly. And exempt employers, a case that recently came out that discussed an exempt employee who was being paid a salary, but chose to engage or enter into a reduced work arrangement with their employer, but ultimately ended up working similar hours that they were working when they were full-time. So here, this is Cooper versus Grupo Gallegos, it's called. The employee was classified as exempt under the administrative exemption, hired as an associate media director for full-time work. So hired to work 40 hours per week at $135,000 per year. They later entered into a reduced work arrangement where they were, of course, the salary that they were being paid was reduced pursuant to the fact that they were supposed to be working less hours. But ultimately, the employee worked basically the full-time hours for a reduced pay. Here, the employee complained and later resigned, and then filed an action with the labor commissioner seeking unpaid wages. However, it was the employee that had entered into the reduced work arrangement He was a salaried employee. He was not being paid based on hours worked, regardless of the reduced work arrangement that was entered into, and was paid the agreed upon salary for the work performed. So the employer here, the commissioner awarded employee unpaid wages for all time she worked above 30 hours per week. The employer challenged this in court. The trial court affirmed the commissioner's award of damages, but the appellate court reversed. So here, the appellate court correctly found that the employee was not entitled to breach of contract damages where she was paid the agreed upon salary under the reduced work arrangement, and there was no provision whereby she would be paid overtime for hours worked in excess of 30. So here, there can be no breach of contract where the contract was not breached. The contract itself did not say anything about being paid extra if you worked over the number of hours that were part of your agreed upon reduced schedule. She was paid the salary that was owed to her pursuant to the agreement made. Here, an exempt employee must receive the full salary for any week in which the employee performs any work without regard to the number of days or hours worked. So that's what the court based its findings on here. Is it doesn't matter if you're an exempt employee that is salaried, you could work 20 hours a week, you could work 60 hours a week, and you still should be getting that exact salary that you were owed for that week in time. And with that, I will pass it over to Shauna, who's going to touch on class actions and PAGA claims.
All right, thank you, Katie. I'm just waiting for my video to get going here. Okay. All right, so Lukas has already touched on some of the issues. Some of the cases Lukas has talked about have involved class actions and PAGA claims. So I'm going to do a little bit of a deeper dive, focusing not so much on the administrative procedural issues that are in these cases, but more about the practical issues that arose in these cases that I think will be most beneficial to you all in how to run your businesses on a day-to-day basis. But inevitably, these are procedure-heavy cases, so I'll try to keep it simple. So the first case I want to talk about is, touching mouse here. The first case I want to talk about is Lawson versus Grubhub. This is a case that was brought initially in 2015 by a food delivery driver, Lawson, who upon hire signed should have signed a class action waiver. Most of the other Grubhub drivers did. It was part of their standard process for their independent contractor drivers. He sued back in 2015 and lost at the trial court based on his claim that he was misclassified and should have been classified as an employee, not an independent contractor. And he also sought business expenses and sought to certify a class and asserted PAGA penalties. So as you may recall, the class action requirements are more onerous than the requirements to assert a class on behalf of others for purposes of penalties under the Private Attorney General Act. So there's, this case ended up being kind of a mixed bag for employers once it made its way up to the Ninth Circuit. But between 2015, when Lawson first sued and lost at the trial court, a lot of things happened, which Lukas has been talking about earlier, including the Dynamex decision that made the ABC test the operative test for deciding if someone is an independent contractor or an employee, and then which was then codified by AB5 in 2019. And then was declared retroactive so that it was effective essentially retroactively. So this case has been sitting in courts of appeal for 6 years, and the Ninth Circuit took a look at the case, and in September of 2021 gave a partial win and a partial loss to Grubhub. On the positive note, because Lawson didn't sign a class action waiver, he could not represent similarly situated workers who did sign a class action waiver. So the court said, well, you're different than these people because they signed class action waivers, and so your class claims fail. So that's great news for Grubhub. The not so great news for Grubhub is that the federal court, the Ninth Circuit, remanded down to the lower federal court to decide whether the ABC test applies to his expense reimbursement claims. So essentially what happened is, even though Lawson's case was tried under the old Borrello test and he actually lost, because in the interim, the Supreme Court ruled that the ABC test was the proper test and that was retroactive, because this case was still making its way through the courts of appeal, it actually got remanded back. And the bad news, other bad news here for Grubhub is that they may be subject to PAGA penalties in addition to just the individual business expense claim that Lawson still gets to have revisited. So it's a bit of a procedural nightmare for Grubhub, and this litigation is dragging on and is costly, but it's an important case for all employers, because this tells us the lesson to be learned here is to make sure that your agreements, number one, contain class action waivers, and we talk about this a little bit more, but the goal is to narrow or potentially defeat a class. And to the extent that class action waivers may be eventually ruled invalid, which we're continuing to watch, we still want to have language in the class action, in the arbitration agreements, settlement agreements, separation agreements, that at least try to thread the needle and say that class actions, that you waive the right to have your case decided as a class, to the extent allowed by law, for example. So there's language that we can put in to try to thread the needle between all of the various laws that are now trying to narrow down the right to arbitrate class actions, as well as the cases that are like Lawson working their way through the system and showing us that those class action waivers still have value, even if they might be narrowed in certain contexts or maybe invalid in others. So make sure that your agreements have these waivers. And I think the other takeaway from this case is make sure that your HR folks are checking off on their checklist. If you have mandatory arbitration agreements, mandatory confidentiality agreements, things like that, make sure that people are initialing and signing off on all the relevant sections, and follow up with people who are new hires or newly engaged contractors if they did not sign a particular form, to make sure that that's something that you're aware of. And if it's a deal breaker for you as an employer, let them know that. If it's optional, just make sure that they intended, in fact, to not sign that, and that they're opting out essentially of whatever arbitration provisions you may have. The other thing that we see a lot is with meal break waivers and things like that, where people have a on-duty meal period agreement. We go through a class action and we think that every worker has signed an on-duty meal agreement, but we find a small handful where we just can't find the form, or the form isn't dated, or the person signed it, but their signature is illegible and they didn't print their name. So just making sure that you're carefully looking through these agreements when you're hiring folks and engaging contractors, to make sure all the I's are dotted and T's are crossed on that. The next case here is the Farah versus Lowe's Hollywood Hotel case. And this is a case that has been long awaited and is one of the most significant, I think, cases this year, and perhaps in a long time, because I think a lot of lawyers were shocked with the way that this came out, at least on the defense side. And the question before the Supreme Court, as this case worked its way up through the Court of Appeal, is a statutory construction question. Does the phrase in Labor Code Section 226.7 and the phrase in Labor Code Section 510A mean the same thing? And a little bit of background here, as you probably know, if you've attended our wage and hour seminars before, if an employee misses a meal period or misses a rest period, and there was a business reason why they did, it wasn't just a voluntary choice. They were not free to take their meal period. The employer held them back and they couldn't take a timely meal period, or the meal period was shortened because the supervisor called them back to duty early and they didn't get their full 30 minutes. They would be owed, this triggers premium pay under Labor Code Section 226.7. And Labor Code Section 226.7 says they get an hour's pay for every missed meal. Well, the question in the FARA case was, did Lowe's Hollywood Hotel properly calculate the way they paid the premium? So in this case, it wasn't that they failed to pay the premiums at all. It's that when they paid the meal premiums, they're paying them at people's base rates. So if Farah, for example, worked and he made $15 per hour as his base rate, before you account for bonuses or overtime or anything like that, his base rate, $15 an hour, they were paying him a $15 meal premium. Well, the Supreme Court had to consider a couple different rules of statutory construction. And the most common one that I guess I would have predicted that they would have relied upon is when the legislature writes a new statute, they have before them all the other statutes in the same category of the same topic, in this case, the labor code relating to the same subject matter. And they are fully capable. These are, statutes written by lawyers with lots and lots of review. They're fully capable of using the phrase and the terminology that they intended to. And if we're talking about the same subject matter and the legislature used a different phrase that means something similar, we assume that they knew what they were doing and that they intended to use the different phrase and that it had a different meaning. So for decades, all of us have been under the understanding that regular rate of compensation essentially means the base rate, whereas the regular rate of pay, which is used in Labor Code Section 510, is a term of art with a body of case law that's developed to say that when you pay overtime is paid at the regular rate of pay. And if you've gone to our wage and hour seminars, you know that things go into the regular rate of pay beyond just their base wage. So the Court of Appeal determined what we expected based on common understanding and consistent with other state and federal court rulings. That's the right rate, that missed meal and rest periods are paid at hourly wage base rate, not the regular rate of pay that you would pay for bonuses, which include, for overtime, which includes mandatory bonuses, non-discretionary bonuses, commissions, shift differential pay, and other non-discretionary payments. The Supreme Court did a reversal on this and they said, no, when words that have the same meaning are used in a statute, unless they're defined basically to be something different, words like pay and compensation are used interchangeably throughout the labor code. And they said that means that the legislature meant to have regular rate of pay and regular rate of compensation be the same thing. I mean, compensation and pay generally are synonymous, and it is true that throughout judicial decisions and the labor code that pay and compensation are often used interchangeably throughout decisions. So I can understand, I guess, where they're coming from, but this was a unanimous decision by the Supreme Court that we've all had gotten it wrong, and all the lower courts and most of the lower courts have gotten it wrong over the years. So the takeaway here for employers is the alarming part of this is that this is a retroactive holding, because when the Supreme Court says this is what the statute means and has always meant, that means that we were all just interpreting it wrong and they interpreted it to mean this other thing. So it's a retroactive holding, meaning employers already, if they have been doing it wrong, would owe premium adjustments if employees were getting paid at the base rate without regard to the other factors that go into premium pay at the regular rate of pay. So we have to think about and make a decision, and this is something you should, talk through with your legal counsel, give one of us a call. We're working through this with other clients as well to try to figure out, what do you want to do? What is your best scenario for dealing with the retroactive piece of this? Proactively going forward, if you have not already done so, we need to make sure that if you work with a payroll provider like Paylocity or ADP, that they are calculating meal premiums correctly at the proper rate. If you are doing manual calculations for premium pay, we need to make sure that your payroll employees understand what parts go into the premium pay and what don't. And a big question I get a lot is about bonuses. Sometimes bonuses are not pursuant to a well-defined written plan. And I would strongly encourage you, if you believe that your bonus plan is not based on production, meaning that you don't get $100 for every X number of widgets you produce over your quota. If it's just, hey, it's the end of the year, the company did really well, we want to hand out everybody a thank you. It wasn't promised, it wasn't planned on. Those discretionary bonuses don't get factored in, but non-discretionary bonuses do. And that is a topic in and of itself that we can talk you through. So going forward, making sure you're doing it right. And then looking back, deciding what to do, going back in the 3 to 4 year period that statutes of limitations would apply. So at least 3 years for labor code violations, theoretically another year if somebody asserts a business and profession code claim for restitution based on the failed payments. So this is one of those situations similar to some of the cases that Lukas and Katie talked about where there's no defense. In other words, ignorance of the law is not a defense, and this isn't a penalty, it's a premium. So there's no real defense to not paying the premium at the proper rate. So figuring out, do you want to calculate your exposure and consider making voluntary payments to at least your current employees, if not poking the bear and reaching out to former employees? Or do you want to just hope for the best and wait and hope that every pay period that drops off where you haven't been sued yet is a pay period less that you'd be potentially liable for? For employers who have a lot of staff and they're constantly making, doing missed meal and rest breaks, I hope that you use forms that allow for people to say when they need to take, they think the premium is owed. And I hope that you have a process in place for your supervisors to confirm for payroll whether or not they agree that the premium should be paid. And the best way to get a handle on your meal and rest periods is training everybody involved on what your policies are and making sure that supervisors understand the great cost in interfering with people's meal breaks and rest periods. So making sure that they understand we have to comply with the law, and payment of premiums is just the tip of the iceberg. Because when people sue, they don't just sue on behalf of themselves, they bring a class action like FARA did. So we want to make sure this is something everybody takes very seriously, and talk with your legal counsel about it. Okay, so moving on to Donahue versus A&M. This is just yet another really significant case on the same subject of meal periods, but this has to do with the way that employers capture time. And so many of you may use automated timekeeping systems. I pick on ADP because it's easy to say, but there are Kronos and other timekeeping systems that have the option or default to rounding your time. And so we all learned a couple of years ago that from Brinker, rounding the start and end time, we don't want to do, we can do that. But now we've learned through Donahue that we cannot round time in the meal period context. So even though the Supreme Court affirmed that you can round off your time, start and end times, you cannot round the meal period time. And here's why. Meal periods need to be exactly 30 minutes or more. If they are even 1 minute shy of 30 minutes, then the meal period is non-compliant. And the case I just talked about says that you then have to owe them a premium wage for the non-compliant meal period. So if you round the time that somebody actually punches in and you round it up or down to the nearest 5 minutes, 15 minutes, whatever, it will make it appear from their rounded punches that all of their meal periods were compliant. They're all going to look like they're compliant as long as they clocked in and out to the point where it rounds up and not down. So if somebody clocked in at 28 minutes, it would round up to 30 minutes and it would look compliant. But if you would go back behind the rounded time punches and you look at the raw data, you would see that this person, in fact, only took a 28-minute period. And so the problem then becomes you can't tell, you being payroll or an employee who's looking at their rounded punches, they can't really tell if the meal periods are compliant or not. So if the Supreme Court's holding in this case was employers cannot engage in this practice of rounding time punches in the meal period context. And if you have rounded time records where they show non-compliant meal periods, it raises a rebuttable presumption that the meal period, that there were violations. So again, the good thing is that the Supreme Court said, they confirmed, let me get to the next slide here. They confirmed that you don't have to force people to take a compliant meal period. You just have to give them the opportunity to do so. And they're still not liable if it was the employee's choice. But the proof is very difficult. So the court made this change in the Donahue case to the way that we prove a compliant meal period. So previously you could say, well, on the face of the time cards, the employee's meal periods appeared compliant. But what the time cards don't say is, did the employee, if there were, especially in the context of rounded punches, did they voluntarily forego a compliant period or did they not? So if you are going to assert a defense in these cases that they voluntarily chose to forego a compliant meal period, you as the employer have the burden to demonstrate that they voluntarily waived their compliant meal period. So I've been working with a number of clients to talk with their HRIS system providers, with Paylocity, ADP, Kronos, all of those, to find out, number one, is our timekeeping set up to round meal periods or not? And if it is, we need to stop doing that. And then I've been working with HR professionals and payroll counsel professionals to counsel them on how to beef up their timekeeping policies and use of some tools that are already built into your software to help us with this proof in the event that you do see a claim for meal period violations. So one of those things, one of the features that a lot of these software programs have is an opportunity where the person can make notes, comment on their time card for the week, and before they submit their pay, a pop-up comes up either on their mobile device or on the time card screen or on their computer, asking, did you have your opportunity to take a compliant meal period? And then also there's ways to flag for supervisor review time cards that appear to have non-compliant meal periods, so the supervisor can have a dialogue with the employee and then confirm in writing, oh, they voluntarily shortened their lunch because they were done eating and they were ready to come back and they didn't want to sit around for another 5 minutes. So there's a lot, this case has a whole lot of moving parts and a lot of really important things, but the keys are don't round your meal periods. And let's talk, if you have questions about how to prove that your apparently compliant meal periods or your non-compliant meal periods, if you didn't pay a premium, were in fact voluntary choices. This, like I said, this case is retroactively effective. So it's, a question of, do you need to make sure that you are, you have exposure for any past time period or not? I would suggest if you do have rounding that you not round at all, because I have some concerns about if you round their start and end punches, but you're not rounding their meal period punches, whether that might create an issue of proof regarding whether they took a timely meal period or not. So in my view, it would be easier to just turn off rounding altogether unless there was some really compelling reason to keep it for your business. All right. So that's Donahue. And then the See's Candy case, this was more of a procedural case. And I mentioned that class actions have lots of procedural parts. One of the requirements of a class action is that you demonstrate, if you're an employee trying to bring a class on behalf of other employees, that you demonstrate things like common issues would exist to allow the court to decide a class across the board without individualized issues of proof becoming an issue where every single person's wage records, for example, need to be examined in order to decide liability on an individualized basis. So it's important for class actions, particularly in a federal context, that individualized issues not predominate and that the common issues predominate. So in this case, See's Candy employees sued, claiming that when they worked shifts exceeding 10 hours, employees were denied that second meal break. And so this, in theory, was, you would think that if they had a policy that says you would only get a meal break after every 4 hours and you don't get a second meal break, that would be a common issue because the policy itself on its face would be invalid or unlawful. It would specifically say something that was against the law. And so that would be a more easy, more suitable issue for class treatment. But in this case, like many of you, See's official policy says the right things. It says we will provide meal breaks after 10 hours, a second meal break, unless, and you can waive the second meal break, etc. But the problem with See's, in the case that the plaintiffs faced in this case, was in practice, See's had a form for recording meal breaks and it didn't have a space for a second meal break. So the plaintiff in this case said, well, because your form doesn't even have a space for the second meal break, that means that it's suitable for the class action, for a class action, to show that this form essentially was evidence that See's consistently has this practice of not providing second meal breaks. So the trial court denied class certification and said, no, we think that individualized issues would predominate because without regard to the form, each person's wage records would need to be examined to see if they in fact did take a second meal break based on their punch records. And the plaintiff in this case, one of their steps that they have to do is to provide a trial plan that shows the court how it will be manageable to deal with all the evidence on a class-wide basis without going into individualized inquiries. And the plaintiff just didn't provide one. So the employees appealed and the Court of Appeal affirmed and said, no, we think individualized testimony will be needed to determine if See's did have this consistent practice. And so that was a victory for See's, that the class certification was denied. So this is a procedural victory just for See's Candy. It doesn't have, far-reaching effects on anybody in terms of the way you're doing your business today, but it is a good reminder, number one, to when we review your policies and you ask us to do handbook reviews, please make sure you provide us any standalone policies as well as any forms that go along with your policy, because when you have a form that somebody in HR created, it may or may not create exposure for you, just like See's Candy's form did, because somebody forgot to leave a space for the possibility of a second meal period. And I would add on something on that form that said, if they didn't take their second meal period, check here and sign off that you waived it. So your forms and your policies can help you. They can also hurt you if they're inconsistent or if the form might be inconsistent with the law. So that, to me, is a good takeaway from this case that as a practical matter, we can all look at when we get back to the office. Okay, and then Johnson versus Maxim Healthcare Services is a case that was brought by an employee as a PAGA action, not as a class action. And they alleged that Maxim Health Services required them to sign these non-compete agreements that were unenforceable. And the plaintiff here had signed her agreement more than 3 years ago, and so her claim was time barred. And so the trial court dismissed the claim, including the PAGA claim, stating that she lacked standing because she herself, this plaintiff, couldn't actually recover because her claim was time barred. But the Court of Appeal reversed and said, oh, she can still bring the PAGA claims, even though her individual claims were time barred. So even though her claims were time barred personally, she was still personally aggrieved within the claims period. And the reason is that when these non-competes they're signed 3 years ago or more, that's one thing, but they have these clauses that say that for a period of time throughout the duration of your employment and for 1 year after that, you are not going to compete with us, and you will, do all these things that were invalid. And so even though her contract was signed 3 years more, she was still personally aggrieved within the time period and therefore had standing. So the takeaway here, I guess, is just, be aware of this. There's nothing any one of us can specifically do in, sort of in reaction to the Johnson case, but it is something that's important to note. And so your employees who have long since been terminated might still come out of the woodwork one day, I guess, is the risk here. I can't think of a good way for you to prevent that, other than make sure, of course, if you have any non-compete agreements, that you have them reviewed by counsel to make sure that they are compliant. So some other noteworthy PAGA cases, again, these are PAGA claims brought under the Private Attorney General Act. And so these are for penalties, not for the wages themselves. But as Lucas and Katie have touched on, the penalties for PAGA are at least $100 per violation, per employee, per pay period. And even though we have lots of good law, you can't stack violations and things like that, even with $100 per employee per pay period for the prior year, and then all the way through trial, those penalties really stack up. And then, of course, attorney fees really drive the value of these cases high. So a couple of interesting cases that have come out. The Crestwood Behavioral Health Service was an interesting one, because traditionally, in order to bring a claim in a particular county, state court, a civil claim, you have to have some connection with that court and be able to assert that, you, for example, lived there, were aggrieved there, you signed a contract there, you were employed there. But in this case, because the PAGA action covers all aggrieved employees, Crestwood Behavioral Health, the court said, the plaintiff's attorneys can pick whatever forum they like, as long as the employer had aggrieved employees working there. So it allows them the opportunity to forum shop. And so you might find a named employee who worked in Sacramento, for example, filing suit in Santa Clara, or more likely King County or Kern, or something like that, where they think they're going to get a better shake. So just be mindful of that possibility. And then the Rosales case against Uber, the court said that the courts will decide in the context of a PAGA claim. The court will not compel them to arbitrate a threshold issue of whether the plaintiff is an employer or an independent contractor. So where people bring misclassification claims, they were independent contractors, they believe they're misclassified. If it's a PAGA claim, you have arbitration provisions, the court will decide the threshold question and the court won't compel it. So it's just another case that kind of keeps along the same track that we've been on, where PAGA claims are being essentially treated by the courts and not by in arbitration. And then finally, Wesson versus Staples. This is a good claim. This is a good case for defendants. It gives us another tool in our arsenal as defense counsel on your behalf. Like a class action, PAGA cases can become incredibly difficult to actually try these cases. When they go to trial, you have to figure out how are you going to decide how many penalties have actually occurred without looking at every single person's punch records and wage records for every single day that every person worked. And so we often try to raise the claim that, well, this is going to be unmanageable, and put the onus on the plaintiff's lawyer to say how it is that their plan will make this manageable for the court to resolve this case without a mini trial of hundreds or more employees. And so in Wesson, the court said PAGA claims as well as class action claims can be stricken if they are so unwieldy that they're unmanageable. So this is great news for employers. It's another feather in our cap or tool in our arsenal that we will use in defending these cases going forward. And I think that is it for the substance, and that leaves us plenty of time for questions. I see 8 cases pending in the Q&A, and I will let Lukas and Katie take it away on answering the questions directed at them, and while I look at any questions that might have come up during my section. So Lukas, looks like you're ready to
Yeah,
fire
it looks
away.
like the first few came up during my portion of the presentation, so I'll try and hit those. There was a question. I got a specific example of a mental health agency. Now, I'll preface this with, we're talking in hypotheticals here and not a specific legal advice to your situation, because I don't know enough about it. But the question is whether they have physicians who are independent contractors, and whether the nurse practitioners can be both contractors and employees. There's not a blanket rule that says somebody, if somebody is, if you have employees in one job, that you can't also have contractors in that job. However, there are a couple areas where I would caution you on that. One is they all have to go through their independent analysis, right? So nurse practitioners are going to be subject to most likely the ABC test. Even if they're subject to the Borello test, you got to make sure you satisfy that to correctly classify them as a contractor. And then the second thing is, if the labor commissioner is looking at this, they tend to, this is kind of my jaded litigator view, but they tend to look for a reason to classify someone as an employee rather than a contractor. And one of the things they'll look at is, do you have other people in your workforce who are employees who are doing the same type of work as your contractors? If so, they're going to usually argue that that is indicative of an employment relationship. So you'd have some risk there. Another question asked was, can an employee sign a document to approve getting paid later than their last day of employment? So if they sign something that says they'll get direct deposit and they get it at the regular payday, can that get them out of the obligation of being paid on their last day? And the answer to that is no. There is one exception, and one exception only, to the requirement that an employee be paid all wages due on their last day of employment. And that's if they quit without notice. If they quit without giving you proper notice, at least 72 hours of notice, then you have 72 hours to cut that check. Other than that, whether in any other scenario, and regardless of what they've agreed to and signed, you've got to make that final pay by the last day, or those waiting time penalties can kick in. Another question was, could AB 1003, and just as a recap, going back to the slides, that was that wage theft bill that said certain type of failure to pay wages could now be deemed a felony grand theft. The question is, can that apply in a situation where to exempt employees where the employer changed the vacation policy effective 1/1/22, canceling vacation time, and didn't pay out what was earned in 2021. So this is a pretty specific scenario, but let's just say we're talking hypothetically here. The answer is probably yes, because when you have a vacation policy, which you're under no obligation to provide, even under California law, but if you're providing paid vacation, under the law, that paid vacation benefit is considered a wage that is earned and not yet paid. So it's already an earned wage that belongs to the employee. So if you fail to pay that to the employee, and you do so knowingly, you're failing to pay all wages owed, which in my opinion could bring you under the purview of that statute. So yes, definitely something to be mindful of. And then the next question we got pertain to agricultural workers whose overtime pay has changed, which is true. There's a change in the way agricultural workers are paid overtime. And the question is whether the employer is the entire corporation or just a division of the corporation. So this is kind of a pretty specific thing. And the answer there, the classic attorney answer is it depends. And there's just, in the context of the information provided in that question, there's just not enough information for me to adequately answer that. What I can tell you is, we're talking about like a joint employer situation, whether, if you have a bunch of subdivisions of a corporation, a bunch of, whether it's LLCs or separate corporations, who is considered the employer, and depending on who's looking at that, by that I mean which state agency is it? Is it the labor commissioner? Is it a taxing agency? Is it a court for a certain type of claim? There are different ways we determine whether the bigger, larger entity would be considered the employer. And it largely revolves around control, similar to the employee independent contractor analysis. But I just can't give you a specific answer based on that. So you'll have to get together with your legal counsel for more information on that. And I think the last one that fell under mine was somebody asked for a clarification with regard to that slide that showed the dual rates of overtime, that how to do that weighted average when someone makes two different types of pay. And it says, can you clarify why we divide the total by 50 and not 52 hours? And this prompted me to go back and look at the slide and realize that there was a math error in there, a typo essentially. You would divide by the full 52 hours. And this is why we are lawyers and not mathematicians, but that thank you for pointing that out. And so you would divide by the total amount of hours worked. Okay. I believe the next few were not for me. And Katie, is that one yours?
No, I think the last three, I'm happy to take any, Shauna, but I think the last three are related to the slides you were talking about with the missed meal penalties, premium pay, all of that.
Okay. And I would invite, you both to weigh in, particularly on the second. I haven't looked at the third question yet, but so the first question is it okay to not pay the missed meal penalty if the employee states they've voluntarily violated the company policy and aren't owed any payment? So yes, if they voluntarily did not take a compliant meal and it wasn't directed by the supervisor, it wasn't necessary based on the work that they were having to perform. In other words, an example I like to give is if I tell my secretary I need this brief to be filed by 1 o'clock, and she normally takes lunch from 12 to 1, and I give her the brief to be filed at 11:59, there's no possible way that she could have taken her meal period because I gave her something to do with 1 minute to do it that takes way longer than that. So if truly a person violated their company policy and you ask them about the meal period and they said, oh yeah, no, I chose not to take a compliant meal period. It was better for me. I wasn't hungry yet, so I took late lunch, whatever. That's fine, but I do strongly encourage you to make sure that that is in writing. It may be understood at the time, but if it's not something in writing that we can present, signed off by the employee that they voluntarily did this, you're not going to be able to prove. And if it's a he said, she said, the presumption is in favor of the employee that they did not get it. So that is the answer to that question. The next question relates to the case that we talked about with Farah versus Lowe's about the calculation of premium pay for meal and rest period violations. And they ask if it includes overtime. And I think that it would include overtime. It's not expressly spelled out in the court's ruling, which I was just re-looking at. And Lucas, if you or Katie remember something differently, let me know. But basically, the way that the court says that so to back up a little bit, what the court says about pay or compensation is that includes all of these sort of non-discretionary things, like a shift differential specifically included as an example, where you pay somebody a split shift because they work for 4 hours and then they take a 2-hour break and then they come back for a scheduled later shift. This happens a lot in the restaurant industry. Somebody works a lunch and then they ask them to come back for a dinner shift, and there's more than a 1 hour in between. And so they're entitled to a shift, a premium for a differential, or for the gap in those times, or additional types of payments, like if you pay somebody $15 an hour to drive and then $20 an hour to do the work once they arrive, those kinds of things. All of those different rates are part of pay, and commissions are part of pay. So although overtime itself is truly, it's a premium, you're paying somebody a premium to work more than your hours. I could argue all day that this would be a circular thing if we just every premium included every other premium and stacked, and in the overtime context you only get one overtime. You don't get overtime on top of overtime. So, but I would say the safest answer would be to include all pay, all types of pay at all rates, and weighting the averages of all those different rates of pay that they worked in the week that they had their missed meal, and use that as the basis to calculate their premium. Lucas, do you, or Katie?
I agree. I think it's not clear, but I think you're safer by including it.
Yeah. So, and I can understand how this can be really difficult for people, in particular when you're paying quarterly bonuses, but you're having to pay people their shift premiums. So you're gonna have to go back at the end of the quarter and see if this added bonus that they got at the end of the quarter, if it's non-discretionary, does that mean that for overtime or meal purposes that you have to go back and adjust that? So if you're already doing it for overtime, you're now just needing to do it for meals as well. But it is tricky, and there's a lot that goes into it. Okay, and then our final question is, we have a holiday policy that states to be eligible, the employee needs to have an approved paid time before or after the holiday. If employee went out, was sick, and only has 2 hours sick left, do we pay them the holiday pay, no, or partial or full? I need to parse through this question. So this is a pretty policy specific question. I think I would need to read what your holiday policy actually says and maybe talk offline about this. Sounds like a very specific situation. Any of us would be happy to answer, knowing a little bit more context, but in general, you can't fail to approve paid sick leave if it's a bona fide use of paid sick leave. So it's different than taking, I think that the concept around a holiday policy that says you only get paid for the holiday if you worked the day before or the day after is to prevent people from extending their holiday with, sort of unjustified use of paid sick leave. But given all the restrictions on questioning people on their paid sick leave, especially in places like San Francisco, where if they only took one day off, you can't require a doctor's note, et cetera, I would be leery about ever applying a policy to punish somebody for taking paid sick leave. So I guess for the good of the group, if somebody has a bona fide sick leave reason to take it, and then you deny them holiday pay, I would see an argument that you are sort of retaliating against them for taking paid sick leave. Lucas or Katie, anything to add sort of on a general level without, knowing what their policy actually says on that?
No, I mean, I think it's just difficult to comment without reading the whole policy. Holiday pay, similar to paid vacation, is a function of not just law, but largely a function of contract. And so without knowing how the policy is worded, it's hard to give specific advice on that. But,
Right.
Like Shauna said, I'd be happy to look at it and talk further about it.
And I would just echo what Shauna was saying, that there absolutely are retaliation concerns that could come up, obviously, depending on the specific situation. We're just talking hypotheticals here, but depending on the specific situation, there are more concerns and potential risks that could come up if you were to decide not to pay someone after taking sick leave.
And if anybody has any more questions, feel free to put them into the Q&A. Right now, we will give you a couple minutes. If any of the questions that we previously answered are, if you have follow-ups, if this was your question and you wanted to add more information, we are happy to consider that. Otherwise, other questions we are happy to take offline, as you may recall them. It looks like we may have a new question. I just can't see where it is.
It's just in the bottom here. It talks about retaliation. So retaliation is a topic that will be covered in the next seminar. They'll go over things related to leave, discrimination, harassment, retaliation, more general employment related issues, whereas this was purely just a wage and hour seminar.
And yeah, so retaliation is definitely a topic that we will be covering January 12th. I think I misspoke on the date when I started out. I think I said the 17th, but January 12th is part 2 of our employment law update, and we are still accepting registration for that session. And so we hope that you will join us for that to make sure you are up to date on all of those other topics. And that would be a little less calculation intensive and a little bit more tangled webs of leaves and retaliation, discrimination, updates on employee privacy, including the California Privacy Rights Act, which takes effect January 1 of 2023, which last year seemed a really long way away, but this year seems very close. And so there are lots of things we want you to start doing in preparation for that. So please do join us for that.
I just saw popped up and I clicked to answer it and it seems to have disappeared, but someone asked what are the new minimum wages in this area. So I once again would just draw your attention to the blog that we prepared. It has a chart. It spells out all the cities across California that have specific minimum wages, as well as California state minimum wage, and then those exempt, the minimum salaries for the exempt individuals as well. There are quite a few cities that have, and counties for that matter, that have specific minimum wages. So I would recommend you use that chart as a resource. If you're not on our blog or did not receive that, reach out to Ramona, who can get you added to that. That way you're getting our updates as they come out throughout the year.
Yeah. And speaking of Ramona, she sent out an e-blast before the webinar with a copy of the presentation, and that has the information on how to request your HRCI or MCLE credits for this session. And if you did not get that, or you registered late yesterday or this morning, we will send a second e-blast out after this with a link to those pieces of information, as well as recording to this webinar. And a link to our L&E law blog, where you can check out Katie's recent blog on the minimum wage and all the other things that we've been updating, particularly our COVID-19 resource hub, and lots of updates on that. So with that, we are still working on finalizing our 2022 webinar and training calendar, and we do hope to have that finalized in the next couple of weeks. Like I said, our next webinar is January 12th. That's part 2 of this seminar. And we have at 9:30, same time. And then new in 2022, we're going to be doing a video blog, and we've already recorded a few video blog topics, and they're just working their way through production. So that'll be an exciting and short little sound bites of information in a different format that we hope you will find useful. So if you have any other questions, please don't hesitate to reach out to Lukas, Katie, or I. Our contact information is in the webinar presentation and will be in the follow-up email as well. We appreciate your time. Thanks for joining us and for your questions. Oh, we do have one new, just a comment. Thank you all. All right, that's it for us.
Thanks, everybody.
Thanks, everybody.